Ready, start. In the judgment of a bunch of writ petitions filed by the Maharashtra Electricity Distribution Company Limited versus Supreme Metal Industries and other commercial consumers, Justice Amit Borkar has ruled on November 28, 2025 at the Bombay High Court in Mumbai that once it is held that respondent consumers used electricity for commercial activity in a premises sanctioned for industrial use. Section 126, subsection 6 of the Electricity Act 2003 applies in full. Neither the assessing officer nor the appellate authority had any power to dilute the rate. The statute binds them. They must apply the twice tariff multiplier para. The High Court has stated further that therefore the request of the respondent consumers that the charges be confined only to tariff difference and that the penal be weighted has no foundation in law. The assessing officer acted correctly in applying the double rate. The appellate authority had no jurisdiction to reduce or modify this statutory consequence. The multiplier fixed by section 126 subsection 6 is mandatory. It cannot be reduced, waived, or substituted by any authority under the Act. For these reasons, the request for penalty has no basis. The liability under Section 126 must be enforced in full as mandated by the statute para. Respondent 1 in each petition is the registered consumer. The sanctioned supply stands in the name of Respondent 1 alone. The contractual relationship under the Act, the Supply Code of 2005, and the conditions of supply exist only with Respondent 1 para. Respondent 2 is a lazy. He has never applied for change of name. He has never entered into a supply agreement with the petitioner. He has never disclosed his occupation or activity as required by regulations 10 and 11 of the supply code. He is not a consumer within section 2 subsection 15 of the act. In spite of this, he has assumed the role of respondent 1 and contested the statutory assessment under section 126. The statute does not permit such participation. Respondent 3 is the appellate authority under section 127. It passed the impugned order para. The dispute arose from detection of commercial use in premises sanctioned only for industrial purpose. The flying squad of the petitioner inspected the premises and found commercial laboratory and testing activity. This use falls under unauthorized use under section 126 subsection 6b. The assessment was issued to respondent number 1. Respondent 2 filed the appeal and secured the impugned order, though he had no right to do so. Para. The premises of respondent number 1 were used for commercial activity without disclosure and without permission. The petitioner has challenged the order of respondent number 3. The appellate authority, which is patently unsustainable, being without jurisdiction and contrary to law at all times. The records of MSEDCL showed respondent number 1 as the only consumer responsible for compliance with the Act and Supply Code para. On January 5th, 2010, the flying squad carried out inspection. It found that no industrial activity was carried out. Instead, it was found that respondent number 2 was operating a commercial laboratory and testing unit. This was admitted on site. The inspection report clearly established commercial use. Such use falls in section 126 subsection 6b1 because electricity was used for a purpose other than that authorized